Mr. Chairman, go ahead.
Well, I'm waiting for my screen to come live.
Oh, okay.
There we are. All right. So it is actually 9:01. We're here for a regular board meeting for Tuesday, July 28th. And we have Commissioner Didier and Commissioner Cook. I've not heard from Commissioner Peck yet this morning.
I'm on the line.
All right. We have all three commissioners. We have Keith in the office handling the phones, Karen handling the recording. So with that, I'll call it to order and ask for the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America
and to the republic for which it stands, one nation,
under God, indivisible,
with liberty and justice for all.
Thank you. Probably at this point, as anybody that's watching, there's public comment, phone number in the front of the podium. You don't need to wait to be called for public comments. You can call in and we'll do our best we can to take the calls as they come in. So we'll interrupt for the phone calls. So with that, first item on the agenda is approval of minutes for July 14 of 2020. I would ask for any addition, changes, or corrections. If not, I'll sign them as presented. Not hearing from either commissioner that there's any changes, I will sign them as presented. And that takes us on the agenda to our first public comment. So, as I just mentioned, don't wait for that comment. Just go ahead.
I do have one caller on the line, Mr. Chairman.
Okay.
Good morning. Is it Lawanda?
Yes, it is.
Hi. You have the floor for 3 minutes.
Okay, so I am just calling because I wasn't sure, and you probably are, about the National Association of Counties, NACO. They have a lot of wonderful information on helping counties save money, and it's an advisory commission that advises all counties throughout the United States, but they really have this wonderful pamphlet about county code of ethics, and I think that it is really valuable for counties. I was thinking about this when Susan Fagan was taken off as our legislature. She was done so not because she had done anything illegal, but because of her ethics. She had overcharged for mileage, and which she paid back, but it didn't matter because the legislature has an ethics commission, and they found it to be unethical. And I was thinking about some of the issues that we've had in our county with overcharging for mileage, for land deals with friends, land that was overpaid for by the taxpayers, that was overvalued because it wasn't given an assessment, giving raises without salary commissions, redrawing districts without district commissions, trying to use CARES Act money to help pay friends for a $5,000 a month Facebook page. I also think that there's a lot of, on the commissions that we do have, a lot of putting friends on that are friendly with the different commissioners. And I really think that we need a ethics commission for Franklin County. And I think under the ethics, we should really stop and think about what is good governance. It's not about what is barely legal or what is legal. It is about ethics. And it is about serving the people. You were called public servants for a reason. And that reason is because you're supposed to be serving the people. And so I think that even whining and dining and being friends with people on different commissions, again, is not serving the people well. And so I would really implore that our three commissioners discuss this and really write down some ethics and look at conflicts of interest and things that could harm the community and harm the people to benefit one or two of the commissioners. So I really hope that you look at that, and that is my advice to you as a citizen of Franklin County and a voter. Thank you.
Thank you, Luanda.
Any others in queue?
Yes, there's a second caller online.
Hello?
Is this Jeffrey?
Well, hello there. Am I on?
You are live and you have the floor for 3 minutes.
Well, I will try to be brief. Hello, gentlemen. I hope everyone is doing well. I'm calling because at the previous meeting, there was discussion about putting an advisory vote forward for splitting our state in half, basically. And I was a little concerned when I heard this because I'm not understanding why an advisory vote is a good idea right now, because it seems like something that's going to divide the community. It seems like a very frightening partisan exercise that doesn't actually represent the needs of the community at this time. And I'm a little concerned that if we go ahead and do this, in addition to dividing the community, it's really only going to further diminish the credibility of our county as an institution in the eyes of the rest of the state. There is no way in which an advisory vote is actually going to do anything at this point. It's not going to be legally binding. So I'm hoping when you folks get to this later in the meeting that you could perhaps enlighten me if you decide to allow this, and enlighten the public as to how it would be anything more than a purely partisan exercise that would harm this community. Thank you.
Thank you, Mr. Roberts.
Any others at this time, Keith?
I don't believe there's any calls on the line at the moment.
All right. We will move on to office business and pay the bills.
Okay, Mr. Chairman, we have two fiscal notes this morning for board consideration. The first is fund expenditures. We'll move for approval of fund expenditures in the amount of $734,969.25 as presented. I would note that this document is normally signed by two members of the auditor's office and the county administrator, but on the copy I've received, I only see signatures from the auditor's office, not from the county administrator. I don't know if the board wishes to confirm that signature before proceeding, but that is the motion for approval.
Commissioner, the original that I have in front of me to sign does have Keith's signature on it.
Okay, the scan I received is probably a few hours old and doesn't have that signature, so thanks for the clarification. Motion stands.
I second, and I too would like to receive these copies before the meeting.
We can do that.
Sure that could happen. So, all right, all in favor?
Aye.
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 And Mr. Chairman, the second and final fiscal item for this morning is salary clearing payroll, emergency management payroll in the amount of $1,002,301.19. And note that this has been signed off by two members of the auditor's office.
I second.
All in favor?
Aye.
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 With that, anything on the phone, Keith?
No, sir.
All right, we'll move on to approval of consent agenda 1 through 3.
Mr. Chairman, move for approval of consent as presented, 3 items.
Second.
Okay. There are no discussions. All in favor?
Aye.
Aye. And that brings us down to admin office business. Ready, Keith?
Yes, Mr. Chairman, I have a couple of items. First of all, I just received this yesterday, so I apologize for not having it on the agenda earlier. but it is a request from the Coastal Conservation Association, both statewide and the local chapter, to sign a letter to the Washington Fish and Wildlife Commission, asking them to consider harvest management practices that would do certain things. The specific ask relates to retaining policies prohibiting non-treaty commercial fishing in the main stem Columbia River for spring Chinook, to continue with the existing 80%, 20% split between recreational and commercial fishing to ensure opportunities remain for marked selective recreational fisheries above and below Bonneville Dam, and retain the existing policy that any unused impacts allow for greater escapement and not be shifted to additional mainstream commercial gillnet fisheries. It's essentially a request to allow fishing in the upper Columbia, which is where we are, equal access to the opportunities of fishing, and not to delegate those mostly downstream below Bonneville Dam. There are a number of statements made regarding the efforts of folks who are in the Tri-Cities area to improve fish habitat. And this request is essentially asking Fish and Wildlife to recognize those efforts and allow equal access or improved access to fishing opportunities up in our part of the river. And so I've sent you by email, and I believe with the exception of Commissioner Peck, I've given you a hard copy this morning. But because the Fish and Wildlife Commission is meeting this Friday, we would not have time to delay it, but I would ask the board to consider signing this letter so that it can be sent in time to be received by the Wildlife Commission before their meeting on Friday.
Keith, I don't have a hard copy, but I did get your email this morning.
Any thoughts?
Yes, as a avid fisherman, I've read through this, and I don't see the attention brought to the fact the Caspian terns are eating the smolt down on that man-made island at the mouth of the river, and the seals and sea lions that are raising havoc with these fish, they're not mentioned either. Or the foreign fisheries in our territorial sea continuous zone of 24 nautical miles and our economic zone of 200 nautical miles. I don't see this mentioned in this letter. I think that it would do us do justice to mention these threats to the salmon also.
Well, I would think because of the time frame on this, it would be follow up with a personal letter from you as a county commissioner so that can get in on the record on Friday.
Mr. Chairman, I think Commissioner Didier makes some valid points about other impacts and fisheries. As I'm looking at this letter, the first sentence, it looks like this is, Chief said this came from the state and the local chapters. It looks like this is a response to a specific policy recommendation. While I agree with the points made, I think it might be best to stick with the letter focused on a particular issue that's before apparently the Fisheries Board on Friday. But a follow-up letter is a good idea, and I'd be happy to sign on to that one too if Commissioner Didier wanted to do that as a group effort. Thank you.
Were there comments?
I support sending the letter.
Okay. I also support the concerns that Commissioner Didier has. I think it's unfortunate we didn't receive this time to really vet it very well. It could have been changed possibly, but at this point, I think it's best to send this the way it is, and And if there's an additional concern letter, I think that'd be proper also.
All right, I will draft a final one for your signature.
All right.
I do have one caller on hold if you want to take that call, or I can continue with administration office business.
Well, let's go ahead and take the call so they aren't sitting too long. Keith, please.
Good morning, Mr. Morales.
Yes.
You have the floor for 3 minutes.
Well, thank you very much. I'm not sure where to begin. Recently, during a commissioners meeting about Governor Inslee's visit to the Tri-Cities on the COVID-19 issues, and Benton and Franklin counties, there was a heated discussion on who and who was not invited to the Governor Inslee's meeting. Commissioner Cook stated that he was the chair, that he had received an invitation and was attending the meeting. But then at the end, Commissioner Cook did not attend, and Commissioner Peck apparently did attend. How did this happen? Did Commissioner Cook behind the scenes contact Commissioner Peck and ask him to go? Are the two commissioners playing keep away from Commissioner Didier? If the public is not aware of this fact, all the commissioners for both Benton and Franklin counties are on the Benton-Franklin County Health Boards. Governor Inslee should have made sure that all 6 commissioners in both counties were personally invited to this most important COVID-19 health forum. Shame on Governor Inslee. If anyone wants to have been invited to this meeting, it was each of the commissioners of both counties should have been personally invited. The commissioners work for the people who elected them. Each commissioner should be in the know on this. At this same weekly commissioner meeting, Commissioner Didier had asked Commissioner Peck how he basically was able to attend and who invited him to this most important COVID-19 forum. Commissioner Peck replied that it was none of your business to Commissioner Didier. Commissioner Peck, this seems to be out of line. Totally wrong on your part. It is all the commissioner's responsibility to know what's going on with this COVID-19. This has ruined people's lives. I think you owe an apology. Since we're talking about ethics today, Commissioner Peck replied, "It was none of your business to Commissioner Didier." Commissioner Peck, this seems to be out of line. Totally wrong on your part.
Go ahead.
It is all the commissioner's responsibility to know what's going on with this COVID-19.
Mr. Morales?
People's lives.
Mr. Morales, we're having a difficult time understanding you at the moment. Something changed on your microphone. Okay, that's better.
Okay, I don't know what you heard and didn't hear.
I heard most of it. Just for the last 30 seconds, you kind of faded out.
Well, I just think it's everybody, all the commissioners has equal rights to these such important meetings. And for one commissioner to say that the others, or at least one, it's none of his business, is just out of line. I don't know where you're coming from this. I understand Commissioner Didier is emotional sometimes, but it's clear that he's supporting the people here in this area. I guess that's all I'll say today. Thanks for your time.
Thank you. Okay, Mr. Chairman,
Yes.
back to administration business. Last week, we had a presentation from a group that is asking for the Board of Commissioners to approve an advisory vote on what's called Liberty State, which is ultimately the creation of a new state using parts of existing states. You'll recall that discussion. We have received some information from the auditor's office regarding the incremental cost of adding that to the ballot. There is still some refinement of that number to be done, but it's somewhere around $3,800 to $4,200 depending on how many issues the state has on their ballot, which I think they've just confirmed this morning. But as they narrow down the number of the ballot, whether there's 2 cards required for the ballot or just if all of the issues can be put on a single card, it changes the formula for how much the state pays versus how much Franklin County pays. But our closest estimate at this point is around $4,000 to add this advisory vote to the ballot. I understand Mr. Beaton, the county auditor, is online. I believe members of his staff may be available as well to answer questions about those costs. And Sean Sand is also on the line if you have questions about the legal process for moving forward with this. Mr. Beaton, I'm going to maybe first direct to you. Do you have any additional comments or information you think would be helpful for the board to make a decision?
No, I think you covered it. It's just that it's a dynamic formula. So, it's going to depend on, because we have a 2-language ballot format, that sliding amount is as close as we can get right now, but it could be more depending on state level advisory votes and that kind of thing. So you did a good job, Keith, I think, describing it.
With that comment, commissioners, what's your pleasure?
Commissioner, if I could provide just a brief amount of information for discussion.
Please.
So just for the information of the public, and I think based on the call that was in on whether or not to proceed with an advisory vote, I think it's important to recognize the real purpose of an advisory vote is essentially extending one of the commissioner's abilities to hear input from members of the public. One of the other options, if we didn't take an advisory vote, if circumstances were different, one option would be to have a public hearing, one that might entail involving several people coming out perhaps to a much larger venue than our courthouse. We could set something up at the Hapo Center if circumstances would allow. I just wanted to make sure that, the public recognizes one of the purposes of an advisory vote is essentially giving the citizens of a particular jurisdiction the opportunity to weigh in and give their electorate a feedback by way of a vote. And so the construction of the wording of the advisory vote would be really important, I think, for the commissioners to consider. If you're utilizing this essentially as a mass format for getting as much input from the many citizens of our county as possible, which is in fact one of the purposes of an advisory vote, then the commissioner should work to gather as much information from what that ballot title can allow, at least within the limits. And we could certainly work with the auditor to meet those time constraints as might be necessary. So I just wanted to put on there that purpose of the advisory vote is really to get that direct response from the public. And since having a public hearing is really not an option at the present time, that is an option for the commissioners to hear from all the citizens as far as the questions that you would pose to be answered. That's it.
Mr. Chairman, Commissioner Peck.
Yes.
I think there's one other distinction that might be useful here. Mr. Sant used the term feedback. That might be appropriate if this were an issue that the board was already considering or was taking up as an agenda item, but it's not. And for that reason, I don't support county funding to put this on the ballot. And because we don't have the opportunity for a public hearing, an advisory measure on the ballot funded by the organization does seem reasonable. I would just want it to be clear that this is not something that's being proposed for an advisory vote because this board has previously discussed or undertaken or seriously considering pursuing this concept or idea or proposal. It's simply a matter of if the advocates are willing to pay for it, absent the opportunity to have a public hearing I would support them funding it so that we would have the value of that input. But it's input, not feedback, since this is really not an issue the board has been pursuing. Thank you.
Mr. Sant, perhaps you could address this briefly. I'm not aware of a private organization funding a ballot question. Is that permissible under our election laws to be able to have an organization put the question on the ballot and pay for those incremental costs?
At this point in time, I don't have that information available. I would certainly make contingent on, if the board wanted to make that contingent by taking action today, contingent on that funding, I will continue to look at that mechanism on how they would sponsor that action. Typically, I believe similar to the other initiative processes that are placed on the ballot more for state measures, there is a mechanism in place to put those there. If typically it's based on signatures that are required and meeting certain signature thresholds, then the county essentially puts that on the ballot. So since we don't have time for that, this is merely an advisory opinion rather than an initiative. That would be something that if a third-party entity was willing to fund and pay, and that was a benefit to the legislative body, they could certainly entertain that. I have not found anything to the contrary, but I'm continuing to research that particular issue. I'm not sure if that has occurred for an advisory vote elsewhere in the state.
And Mr. Chairman, I just add one other thought, which is the content of the advisory question to go on the ballot, as Mr. Sant pointed out earlier, does matter. And I don't know a mechanism for us to receive that content and approve it as a board before the time would run out for this to get on the ballot. But my support would certainly be contingent on knowing the language.
Just for your information, next Tuesday, August 4th, it will be the primary election day, but that is also the cutoff date for things to be placed on the ballot. So if the board so chooses, we could have the resolution ready for next Tuesday's meeting.
Okay, thank you. That's helpful.
Mr. Chairman, I would like to see if they would like to proceed with this and pursue private funding for it. I'm all in favor of reviewing that August 4th and possibly getting it on the ballot.
Yeah, I think all three of us were on the same page as far as that. It's, it's difficult. I have no idea what the other approximately 18 counties are thinking. It won't help much if you get 2 out of 18 that are for it, because it won't go anyplace anyway, besides an expense. So I would like to hear from the organization as to what the other counties are thinking also.
Members of the board, this is Sean Sant again. Just a quick question to consider. I did not see any of the proposed language from the organization. I did see some materials from the Secretary of State's office that was sent out Friday, and I've looked at and reviewed the Attorney General opinion that was associated with that. I guess the question is for the organization, even if we don't have the specific language yet, is the intent to provide to the identified counties the same language? Because I think that would be helpful for the board's consideration of having a specific language that identifies what the proposed boundary is, what the proposed counties that are being proposed to be included with this measure. I think that would be helpful for the board, and I could certainly work with the board for any specific language. It would just be nice to know that we're putting forth a similar advisory question to all the affected electorate within the area that is being proposed. And I'm not sure if the promoters of the motion have gone that far yet, or if they're still in the refinement stage. As indicated, we do have until next week, and we can continue to work with making sure that could happen. Just a thought to throw out there, if they're already working on it, it would be nice if they were able to propose to all the respective involved counties to have a similar language so that everybody's getting a feel for the interest moving forward.
Okay. Any further comments? I think we could ask the proponents if they have any further information and or wording for a proclamation.
I will do that. Thank you.
Okay.
The other item was just to update you on the CARES Act funding agreement that we entered into with Tridec last week. I've received some preliminary proposal information. We'll be meeting with them this week and hopefully get that finalized so that we're ready to launch. But I'm working with Carl Dye over at Tridec to finalize all the specific details of that. Other than that, I don't think I have anything additional, Mr. Chairman, and there are no callers on the line.
All right.
Mr. Chairman?
Yes.
If I may ask our Administrator Keith Johnson a question, and the question is, when we first went to the electronic type of meeting, were all the elected heads given the call-in numbers so that they could participate?
My understanding is they were. I'd have to go back to verify that, but as far as I know, yes.
Well, because last week we had a question for the auditor, and he was trying to call in, I guess, according to Jeff Burgard, on the call-in line for the participants from the public. And he is on today because he got this from Karen. Karen sent it to him, all the heads. I don't believe they did get it. And if we're going to have official business done by the county, we need to have all the department heads online, as I have questions today for the sheriff, the treasurer, and the auditor. And I'm hoping that the sheriff is on the line. Is Sheriff Raymond on the line? I guess he's not.
Does not sound like he is.
Yes, my question to Sheriff Raymond is, we are actively putting up President Trump signs for re-election, and we've already had 5 signs either painted over or cut up. And we are now in the process of putting up cameras to catch the culprits in action. And if we do, we want to press charges to the extent of the law, and we want to make sure that it's going to be enforced, because this has got to stop. These are signs, these are private property, and they're on private property ground, and we're having trespassers come on the land and doing this to these signs, and it's got to stop. Second is for the treasurer. Is the treasurer on the line? We don't have the treasurer on the line.
I am.
Right. Oh, there we go. Okay, I would just like to ask, how are we doing on our tax collections for property and sales and everything else? Are we staying at par with what we were doing previous years?
Yes, we are.
And the property tax is on schedule as if it was a previous year without the COVID crisis?
Yes, we are currently at 57% collection.
Fantastic. That's good news. Thank you very much, Josie. And then third is the auditor, and I would like to ask the auditor, who I know is on the line because he's already commented, how are we doing with our election turn-ins? Are we on par with previous years for people participating in this most important election?
Through yesterday, we were at 11%. So, I think I read that Benton County was at 15. So it's, it's a little below, but it just depends on what the comparators are.
Compared to the last election, where are we at compared to 11% at this time, the previous election?
We're about even,
Okay.
you know, but I mean, but it indicates it's going to indicate a mid-30s turnout.
Okay. All righty. Thank you. Those are my questions. Thank you very much.
Okay. All right, with that, anything else for the good of the board today?
I could just add, this is Sean Sand again, I could just add, Commissioner Didier brings up a good point. There's signage every year, every election season, there's signs that are removed or destroyed, whether on the public right-of-ways or private property. And what he's referring to, it's a misdemeanor crime cited in 29A.84.040. A person who removes or defaces lawfully placed political advertising, including yard signs or billboards, without authorization is guilty of a misdemeanor, punishable by the same extent as a misdemeanor that is punishable under 98.20.021. So if the sheriff's office or any entity does take a report and we get information, those will be looked at and reviewed and prosecuted as appropriate.
Thank you. And I have one more thing here. Last week, United States District Court, Western District of Washington at Tacoma, Judge Settles came up with a finding on some suits against Governor Jay Inslee. And the suits in this finding says that he can't be held responsible and sued over his proclamations. And the reason is, it states on page 3, line 17, in this case, Governor Inslee argues that the court lacks jurisdiction to consider the claims against him because he does not have any connection with the enforcement of the proclamations, which means he cannot enforce his proclamations. Although Governor Inslee concedes that he has authority to issue, amend, and rescind emergency orders, he contends that enforcement powers lie with other officials. The court finds the governor's argument not only persuasive, but also consistent with the Fifth Circuit's holdings. So here we are participating in proclamations. In fact, our meetings is a proclamation too of the suspension of the Open Meetings Act, where it's not being enforced. So I don't know why we're not in the meeting room. And I encourage the other commissioners, and especially the chairman, Cook, that we start revisiting the chamber and having normal meetings, because this cannot be enforced by the governor.
If I could address that lawsuit or that ruling, it's a 5-page ruling. If I could address to the other board members as well as Commissioner Didier briefly.
Please.
So just for background, and I just want to make sure that I'm reviewing the same case that Commissioner Didier rose. This is the Drew McCowan plaintiff case versus Jay Inslee as the defendant. And that was issued from the Western District of Washington, Tacoma, last Friday. Is that the opinion that you're referring to?
Yes.
Okay. So just to briefly explain, there's several plaintiffs. Drew McCowan is the main plaintiff, but there's several others that are listed on there as plaintiffs. This was an order denying the plaintiff's motion against the governor. And I think it's important to understand a little bit of the background of what the motion is, because as the discussion points out, the 11th Amendment of the Constitution creates an important limitation on federal court jurisdiction, which generally prohibits federal courts from hearing suits brought by private citizens against state governments unless those states have granted consent. In other words, they have created a mechanism where individuals can bring suits in federal court. So that's the first hurdle that has to essentially be overcome. One of the findings here, though, is the Ninth Circuit, which is the law that they made reference to. There's a court case, LA City Bar or LA County Bar Association. So that went up to the Ninth Circuit. And that opinion has basically held that the connection must be fairly direct as to the enforcement mechanism. So a generalized duty to enforce state law or general supervisory power over persons responsible for enforcing the challenge provision will not subject an official to the suit. So really what this is talking about is Governor Inslee is no more empowered to stop people for violating speed regulations or any other laws in our state. And so they basically, trying to overcome that first hurdle, they have to show that the person that is being sued actually has the enforcement responsibilities. In other words, they are like a sheriff who is enforcing that particular mechanism. And so the petitioners were not able to overcome that. And so essentially some of the language throughout the suit suggests that the governor's proclamations don't have authority, but the governor simply conceded that he has the authority to issue, amend and rescind emergency orders, but the enforcement powers lie with other officials. And that's the important distinction with this holding, is it's basically finding similar other states that have had similar suits brought forward, similar to the governor of Texas was sued based on issuing or postponing non-essential surgeries and procedures. And that triggered a suit, challenging that. So similarly situated with our governor drafting up ordinances, it says the ruling further holds that the governor is directly responsible for initiating or promulgating the law, but that is not the same as having the power to enforce it. And that's similar to a legislative body that passes the laws. They are passing the laws, they're not tasked with actually the enforcement. And so while that brings up some interesting language, you do have to read the 5 pages of the order. Essentially, that order did deny the claims by the plaintiffs. It did nothing to take away any of the governor's authority to issue proclamations. It simply distinguished that the governor is not the person that is tasked with actually carrying out the enforcement of those orders. In other words, the governor is not the one that is going out and charging people or prosecuting them for violating the governor's order. So I think that's an important distinction. It doesn't go in and it does not say that the governor's powers are not unlimited. And so there's certainly a check, but that suit, I am not aware, has been raised or entertained yet by our courts. Certainly not with a ruling yet from either the federal circuits or within our state court system. I know there's actions that are pending, but we have not yet had a ruling that says that the orders or proclamations are without constitutional or statutory authority. But it is an important case, and I appreciate the board having that opinion in front of it, but we should look at the entirety of the opinion as it was a denial of the plaintiff's motion against the governor. So as it now stands, I'm not aware of any ruling that has sustained a claim that the governor is acting outside of the authority granted to the governor by the legislative authority. And I think there are several. I have heard there are some initiatives trying to address and move forward to limit governor's authority, but I'm not aware of the status of those endeavors. And I believe I have also heard that there will probably be some discussions at the next legislative session where the legislature will re-examine or reevaluate some time limits on the grants of authority. But as of now, the current law, as it stands, provides the governor has the authority, and certain orders or certain proclamations, depending on the section that they are cited to, if it's a Section 2 statutory provision, that does still require the four corners approving of those. And currently, I think the provision that we're talking about continues through August 1. So we will have to wait and see. As that date is approaching quickly, we will see what kind of amendments might be forthcoming. So this is obviously a never-changing or ever-changing situation, and we're doing our best to keep up with all of the proclamations to let everybody know of any status change.
So question, Sean.
You bet.
Who are the government bodies to enforce this in our county?
Well, so this would be just like any other crime, just like the one with the destruction of campaign or political signs. It would fall either under the sheriff or it would fall under the law enforcement agencies within the jurisdiction. And then ultimately those referrals or cases would be referred to our office for prosecution or review of the case. So just like any other case, we ultimately will we ultimately will have to decide whether or not it meets prosecutorial merit. We have considerable discretion, and I believe the sheriff has been on record of exercising his discretionary authority. And that's subject to, the sheriff will review that. We, of course, I'm not going to make a statement out there until I see the facts of the case, because I need to make sure that we would have evidence that would support the charge under all the circumstances surrounding it. So ultimately, we would review that case, but it would be up to the local law enforcement or the local sheriffs to send a referral of the charge, or they could make a citation on the spot if they felt that that was appropriate. But I believe it has been consistently stated to me that they would likely be referring or sending any alleged violations to my office for review, and ultimately making that decision on whether or not it meets the merits to move forward and prosecute.
So in other words, what you're saying is we would have to be complicit in our own demise. You would be the one that would have to charge our county with being out of compliance.
Or the Attorney General's office. The Attorney General has authority within the state, and they can be requested at the request of the governor to take enforcement action if they feel that any of us individually.
Well, now, Sean, according to this case, the governor he's only made suggestions, which are proclamations. If he calls in the Attorney General, now he's turned the page, and now he would be held responsible, correct?
You'd have to look at the facts and circumstances, because again, still, the governor is not the one that is directly responsible. So you'd have to look at that, and that would certainly be something that could be looked at. But I don't think it's rising to that level, because even if indirectly, the Attorney General ultimately would have authority to make a charging decision. The governor does not have authority to tell the Attorney General to go out and arrest anybody. Or what the Attorney General would simply be tasked to do is review the facts and circumstances of a case. In other words, if they found that the Franklin County prosecuting attorney was not doing their job, the governor could request, hey, Mr. Attorney General, please go out and check on this issue. If the Attorney General then decides that there's a case that the prosecutor is not taking action on, the first step is the Attorney General would have to make a recommendation to that prosecutor to say, hey, in my case, if it's our county, the Attorney General would have to say, Mr. Sant, we have reviewed or investigated this case. We want you to take a second look at it. If they are not satisfied with my response, then they can take on that enforcement action. But again, that's an independent enforcement action, what is assigned to the Attorney General's office and not directly to the governor. So the governor wouldn't have the authority to ask or command anybody to go out and take enforcement action or arrest on there, at least under that kind of provision with the Attorney General interaction, if that makes sense.
You sort of talked yourself in a circle here, but you're not making a lot of sense to me, because this is pretty clear. The governor does not have the authority to enforce this. It takes a local, and our sheriff has already said he's not going to enforce it. And so then it would be up to the Attorney General. And you said if the governor directed him, then he would have a connection, and then he could be held responsible, because underneath of our U.S. Code 18, Section 241, when there's harm to any individual on these type of actions, it is a pretty severe punishment. And that's what he's looking at now. That's what has been filed against the governor, is the 18 U.S. Code Section 241. And I'd encourage everyone to look it up.
And that's good. You still have to overcome the 11th Amendment of the U.S. Constitution to get to that position. But that notwithstanding, I wanted to focus on what you raised. I want to be clear. In this particular order on page 3 that you referenced, what it says, although Governor Inslee concedes that he has authority to issue, amend, and rescind emergency orders, he contends that enforcement powers lie with other officials. That is absolutely 100% correct. And our court, the Western District Court, found that the governor's argument was not only persuasive, but it's also consistent with the Fifth Circuit's holding in the case In re Abbott. That was a 2020 case as well. And that's the case arising out of Texas. So essentially, it said in that Texas case that the governor of Texas was also in a position not to be enforcing the order, but the governor is the one that's promulgating those kind of regulations. And so it cuts both ways, but this holding essentially adopted the fact that it recognizes the governor does have authority to issue, amend, and rescind emergency orders, as the bottom paragraph states on page 3. And that has not been challenged. That provision has not changed. And right now, when I said the governor doesn't have authority to enforce, just like the governor doesn't have authority to pull someone over for a speeding violation, that's still a valid law, and it's enforced by other individuals. Even though the governor can make the request of the Attorney General's office, the Attorney General is an independent office, and they must use their own independent discretion and determination on whether or not a crime or violation of the proclamation was committed. And so they still have to do their own independent analysis, and that's what the court is focusing on, is because the governor is not the one. It has to be a direct connection to enforcement, and not just some generalized duty to enforce state law or general supervisory power. It has to be a fairly direct, and that's what's cited from the Ninth Circuit Court of Appeals. And so I think that's the important distinction. Again, I haven't seen the particular arguments made as you're suggesting, that merely the request of the Attorney General, that does not seem to rise to the level of the one tasked with enforcement. And if that's not the case, the federal courts are going to be barred, because at that point they lack subject matter jurisdiction, meaning if they can't get over the hurdle of being able to show that direct connection, they can't even address the merits of the other claims under the 11th Amendment. So it's a fine balance of all the constitutional amendments and the other federal laws that must recognize the independence of states as well. So anyway, good discussion. I just wanted to make sure there was context with the order, because I did review that on Friday when it came out, and that did not change, in our legal opinion, the current status of any of the current proclamations. And I think that's the important part for the board, is nothing has changed on whether or not proclamation, I think it's 2028.7, that is still in effect through August 1, unless we hear otherwise by further proclamation before the end of the month.
But again, that is just a suggestion by the governor. This is not law, according to this finding.
That is incorrect. It actually, they did not address the fact of a state law issue. The proclamation authority that the legislature granted to the governor also states that the punishment is a gross misdemeanor for violating the governor's proclamation. So essentially the legislature has already made the decision. It's not the governor that says, hey, I'm going to prosecute you. It was the legislature that basically is authorized to grant the governor his authority or her authority under state law. And so the legislative branch has granted the governor the authority. They amended it last year. They took out some provisions, but they added others. One of the provisions that was modified was the 30-day provision, essentially for certain statutory issues. And that's why you will hear ongoing discussions between the governor's office and the Four Corners, or the leadership and minority leadership of both the House and the Senate. And that is an important distinction, and that's the balance of power that the legislature thought was appropriate last year when they addressed this modification. And like I said, nobody anticipated COVID or a long or prolonged emergency. The only similar prolonged emergency that was close to this case was the Cougar case, which goes back to the city of Cougar, Washington, where certain businesses were adversely affected with the closure of their businesses because of the threat of Mount St. Helens. And that was approximately 6 weeks before the big May 18 eruption. So that was challenged under similar grounds, and that also was denied. I recognize there's different circumstances, but again, we're faced with the fact that if a state of emergency arguably exists, if the state health department, which would be the basis for a court to hear whether or not there's a state of emergency present, I agree with you, as we've discussed, that certain limitations or discretionary actions might not make sense. We might not agree with it, but the idea that the governor does not have authority has not has not been proven yet in a court. And so these governor proclamations are enforceable. They are valid and until we hear from a court otherwise, we must presume that those laws are constitutional as contemplated and previously passed. I agree with you. We don't have to agree with it, and we certainly don't have to agree with the discretion. And I guess fortunately, everybody has the opportunity this year to make a decision because it is an election year. But the discretionary acts of a governor is a much different issue than the governor's constitutional authority or legal authority or statutory authority. And I have not seen any court case yet that has said the governor does not have the authority to issue proclamations when dealing with issues of public health and safety. Similar when we've had landslides or the threat of earthquakes, that's what was contemplated when this statute was actually amended and addressed and discussed by the legislature last year. So we will continue to monitor the court cases, Commissioner Didier. I agree with you. It needs to be looked at and monitored, but I think it's important to recognize whether I agree with it or not, my job is tasked to try to follow and be compliant with the law. And I'm trying to give you the best and current information that I'm receiving and trying to give that information to you and answer the questions that will come to you or are posed to me from the board. So I appreciate the opportunity to look into that. And if you have additional questions, I'll be glad to meet with you offline and we could discuss further.
Just an additional request. I would like to see you quit putting so much time in how to keep us out of the chamber and more time on how to get us back into the chamber so that we can give our residents and our constituents of Franklin County a sense of getting back to normalcy. So I would like to see you engage in trying to get us back into that chamber. Thank you very much, Sean Sant.
Thank you, Commissioner Didier.
Okay, anything else for the good of the board this morning?
Commissioner Cook, I have two callers on the phone.
All right.
Good morning.
Oh, well, good morning. It's Jeff Robinson again. I'm calling because I had a request of the commissioners. I would respectfully request that when you're describing your political activities outside of your job, that you make it very clear that you are acting as private citizens, not as commissioners. As a minute ago, Commissioner Didier was talking about his personal private activities in relation to Trump signs, but the way he worded that made it sound as though the commission as a whole was taking a political stance. And while I'm pretty sure that's not what was happening, at the same time, it risks, when you're not clear, adding to the perception that this body only chooses to do things for political or partisan reasons. I would also respectfully request that when the commissioners are addressing the county prosecutor, that they do so with deference and respect as a co-equal branch of government. Giving him orders, bullying him, and being aggressive towards him, which is how that last statement came off, is not appropriate, and you are welcome to your opinion. But please, for the sake of unity in our county, and for the sake of upholding the standards of the office, please try for some civility and professionalism. Thank you.
Thank you. Good morning, Michelle.
Good morning, Michelle Andrews. I would have to echo what Jeffrey just said. Sean Sant has gone out of his way to clarify the legal standing, and we are operating as best we can. And I am exhausted with the continual challenge because of frustration of our Commissioner Didier constantly challenging what is in fact the law. It is exhausting. It is exhausting. It is divisive. None of us like this. All of us want things to move forward, and there is a way to do it. And I came to this meeting at the beginning of the year, and I called for everyone to get along. I proceeded to emphasize that with a call to prayer and emails, and I am so distraught on what I have seen happen outside of this venue. The allowance of the kind of comments made to Keith Johnson publicly. I am dismayed at some of the acts of citizens that call themselves patriots. I am utterly dismayed. I support my legal officials. I pray for you daily. I am so sorry that things have come to this. Attacks have been made on our city council members as well. And it is just very clear that when there are other meetings outside this venue, that not the whole truth is told. And I'm being very courageous in trying to say, look at the bus in your room. Benjamin Franklin called people to go and bow the knee to the only one you can and pray and let him show you a better way. Every single person in this room or on this phone call says that that is their source of higher power. And I call again, because the destruction is deep, wide, and long. And I remember the day that Keith came and applied for this job, and I sat out on the bench just introducing myself, asking who he was, and how much I told him what a beautiful community this is. And how much I hope that he would come. And I would say to Mr. Didier in his other capacities as chairman of the Republican Party to start building and bringing consensus. And I'm sorry, Jeffrey, I don't want to bring the political stuff into this, but it's inseparable when one person holds a position for both. And so I just stand in that call. I do not even care if our citizens are D's or R's. They are my neighbors, and I care for them, and everybody in that courthouse. The work that they do is exhaustive because I've called them, I've talked to them, I've encouraged them. I continue to do so quietly behind the scenes because I have been beat and dismayed and shamed by some of the same people. And I will not allow it. I will stand. I will stand for the law and wait for the way forward when there is a consensus. But the division must stop. And I hope that every single one of the commissioners hear me today. And that is all I have to say.
Thank you, Michelle. No other callers at this time, Mr. Chairman.
All right. Is there anything from the board? Hearing none, we are adjourned for July 28th. Thank you.
Thank you.